So you may have read in today's Chronicle that just yesterday we introduced a bill. It actually has a bill number now. It will be SB 129, and it's our medical cannabis patient employment non-discrimination bill. And I'd like to ask, just with a show of hands, if you or anyone you have known has had any kind of employment discrimination as a result of your status of being a patient. That's a lot of hands. That's a frightful number of hands. Thank you. Well, that's why we've got to get this done. And again, I think this is such a reasonable bill. You can tell I love fighting reasonable battles. It's just they fuel me. They just fuel me. But if you take the decision of the California Supreme Court in this Ross versus Raging Waters case, case, the logical conclusion is that the voters of California in 1996, when they passed Prop 215, intended it only to benefit unemployed people. And that's just... Dennis, was that your intent? I know you're in the room. Yeah, I mean, that's just craziness. Voters did not intend for it to only benefit unemployed people. And at a time when we've got over 12% unemployment, the idea that we would actually exacerbate our unemployment problem just because people are well enough to go to work. Don't we want them to be well enough to go to work and to be able to sustain themselves, not need public assistance, not need Medi-Cal, not need unemployment benefits? We want people employed. It makes sense all around. And we have written this, dare I say, very reasonably, so that we have exempted those in safety-sensitive positions. So if you're operating heavy machinery or driving a school bus or you provide health care, you won't get this protection. But that's current law anyway. But then we don't change anything in current law that says that you're not allowed legally to be using your medicine at your place of employment or during working hours. So that doesn't change either. So there's no liability to employers. And we also want to shift the focus from these drug tests, which are all about identifying metabolites in the bloodstream, but don't address the issue at hand, which is impairment. And we're not suggesting, nor did we ever, make the point that someone should be able to come to work in an impaired condition and can't do the job. That's not what this is about. And so there are impairment tests, which are cheaper than the blood and urine tests and bring results immediately, as opposed to the week or two one has to wait for the blood and urine test. So it actually is better for employers, better for employees. And so when I heard about Gary Ross's situation, this was an Air Force veteran who had been harmed as a result of his service to this country. And he was suffering with back pain for many, many years and prescribed all of these opiates and narcotics, and nothing was helping, and all of it did impair him and clouded his mind. And after the passage of Prop 215, friends suggested that he try cannabis to deal with his chronic back pain. Well, surprise, surprise, it worked. And so he got a job with RagingWire and announced to his employer that he was a medical cannabis patient, and so hired with full knowledge. And in fact, right before he was fired as a result of a positive drug test, he had just gotten a bonus and a raise in his responsibilities because he was doing his job so well. And suddenly he was fired just because of his status. So all this bill does is very simply and very clearly puts into statute that a medical cannabis patient has a right to employment in California. Fierce champion of the reasonable. You know?